The judge locks this into a procedural lane, not an emotional one. This isn't about who's right or wrong. It's about whether the legal threshold for adequate cause is met. That shift matters. It strips both parties of narrative control and forces them into a narrow evidentiary box. The father tries to play it smart by pre-framing his claims as post-order incidents, showing he understands the rulebook.
This is a motion filed by Mr. Zimmerman for me to find that there's adequate cause to then move on to a hearing on a potential new proposed parenting plan. I'll hear briefly first from you, Mr. Zimmerman, and then from Ms. Zimmerman. Let me just first clarify, Ms. Zimmerman, I did receive your response and objection to the petition to change the parenting plan or to find adequate cause. And so I'll have Mr. Zimmerman go first since it's his motion, and then I'll come to you to let me know your position, okay? Okay, go ahead, Mr. Zimmerman.
So when I filed the paperwork, I also read very carefully that there could be no allegations used prior to the original signing of the original order. So these are all instances or instigation or incidents that happened after the signing of the parenting plan. And I didn't have time to do anything, but there was another incident that happened the night before last, where somebody threatened to beat my daughter's ass, break her cell phone in half, and take things from her that didn't belong to him. This was a gentleman who is staying in Miss Zimmerman's garage. From my understanding and what I've been told by several people is that this person is an active addiction. There was an incident where my daughter and Miss Zimmerman got into a confrontation, and this gentleman stepped in and started overstepping his boundaries and threatening our daughter. It's been an ongoing situation. I've received phone calls from Child Protective Services. I had to go in and speak with them. I have also received text messages from Desiree's oldest daughter, Megan, about the situations that have unfolded, as well as our own daughter, Sarah Zimmerman. It's just been a constant situation of poor parenting choices. And this is all stuff that has been happening since the original signing of the original order. And so I'm really concerned about the safety and well-being of the children. Instability, I do know that she has gotten employment, which is very good. That's awesome. I am very happy for that. However, I am really still concerned about the safety of the people that are allowed to be around our children, and it is very concerning for me.
Help me understand the timeline a little more, because to find adequate cause, I have to find that things have changed. And I heard what you said about a recent incident. This is a situation where the parenting plan between the two of you was finalized on September 6th of 2023. And then you filed your adequate cause request on September 22 of 2023. So what happened in that interim period that you believe changed?
I do know that Ms. Zimmerman has informed me that she had served her landlord with a notice to vacate the premises, but I was informed by her landlord that she was served with eviction papers or to leave the premises due to drug activity, traffic, and loud parties and kids all night stomping around. The neighbors have reported to her landlord, as well as informed me of every incident that's happened. There's the attack on Sarah, where she was drugged to the ground by her hair and drug out the door, and Desiree's excuse for that was that the police told her that was okay to do it. There's the suspicion that Desiree was still using from not just myself, but a bunch of other people, including one of the children. These are all things that have happened since that day. So these, I mean, it was like I got flooded. My inbox was flooded. It's very concerning. So I don't mean what you mean by the timeline or what's going on. That's the things that I've received since the signing and agreement on the divorce papers.
And so the eviction or moving out notice, was that after September 6th?
Yes.
Okay. Okay.
Well, I was notified about it. Yes.
Got it. Okay. Okay, let me go to you, Ms. Zimmerman. I have read your response. What would you like the court to know? We can't hear you. I don't know if your audio is connected.
So, Your Honor, this has been a very difficult divorce and separation. In the beginning, we tried to do things as just roommates, and then things became very physical. And when I asked him to leave, he refused. So I ended up grabbing what I could and living out of my car for months while still paying the rent and bills while he was not working. I'm bringing that up because it's just been very, very, very difficult for the kids. They've been through a lot. Eventually, I was able to get back in the home and had him removed. And when I first returned back in the home, it was very chaotic. The kids had control over the home from all of the times that they were left to fend for themselves. And I did at first parent out of guilt because of everything that they had been through as children.
The mother pivots hard into context, trying to reframe the entire situation through past hardship. This is a classic defensive move. Shift focus from current allegations to historical struggle. It humanizes her, but it doesn't directly answer the court's question.
Tried to be understanding, but with the help and guidance of my mental health counselor and my sponsor, NA, I began to take control over the home and put my foot down and stick to my boundaries and rules with my children. And because of that, my oldest daughter, my 16-year-old, has been on the run. I'm trying to not involve the people who have wrote out statements because of backlash. And because of how they are connected to Chris and myself in the long run.
Yeah, so hold on, ma'am. I'm going to try and hone you in a little bit. So I understand also your case has been going on for a bit of time. And you guys thought you had resolution and now you're back here.
Yes, I'm getting to it.
I understand that, but well, that's what we need to focus on. The only thing in front of me is, has something changed since September 6th that would warrant me revisiting the parenting plan? So that's my question for you is you have filed a response to the main allegations are eviction, living conditions for your children, drug usage around the children. So what can you tell me about those primary issues?
With the homelessness, at first, the landlord did give me a 10-day comply or vacate because I was being accused of several people living in the garage. And in my response to that was a video that I sent to her that the garage was empty. And she said that was more than enough evidence. And I informed her then that I was actively looking for a place to live because of the toxicity of the neighbors around me, including the ones next door.
Again, I'm going to try and phone you in here, ma'am. Let me help you understand a little bit. We're not here on a full-blown trial of the facts. This is a very quick fact-finding type of discussion where I decide, is there a threshold showing for adequate cause? And then we move on to an actual hearing on what a parenting plan should look like if I were to grant the adequate cause. So let me ask you a couple pointed questions.
Thank you.
One is, do you have a home you're living in now?
Yes.
Were you evicted since September 6th?
I have my a copy of my letter that I gave to the landlord stating I'd be out by the end of the month.
Okay. Where are you going at the end of the month?
I am waiting to hear back on 5 different places that I've applied for and still actively searching. I just got my housing amount printed from HUD. And worst case scenario is I will be staying temporarily at the community house because the safety of my children, because of how toxic the neighbors are there, including the drug house next door.
Forever to go through.
If I'm not hearing your case right now, please mute. Mr. Scrimshire, you're not muted.
I'm sorry.
So Ms. Zimmerman, by the end of the month, you're not sure where you and the children will be living. And right now, your only option is community house.
It's not my only option. I'm waiting to hear back on a few different places. They're going through applications.
Okay.
But worst case scenario, living at a homeless shelter has nothing to do, or would it disqualify me as a good parent?
That's not the question. The question is not whether you are disqualified as a good parent. The question is, has there been a substantial change in circumstances since you guys entered the parenting plan where the court would want to revisit what that parenting plan should look like? So not a question of your fitness as a parent related to your housing. There is a question about drug usage around the children and perhaps someone who may live with you or live near you that has been a bit unkind to a child. What can you tell me about that?
I do have a friend staying with me temporarily. I know him from Narcotics Anonymous. He did stand up for me and help correct my child. He did not overstep. She was being very disrespectful. I had already taken my sleeping meds for the night when the toilet overflooded and I was trying to clean it up. I was there present. Him and I have already had a discussion about that. I do know that the children do a lot of back and forth.
The judge zeroes in on that instantly. This isn't about one incident, it's about authority. Allowing a recently introduced adult to step into a disciplinary role crosses a boundary the court takes seriously.
And I try my best to have an open communication with him and take that into consideration. I have on my phone our daughter letting me know, sending me a picture of her holding his girlfriend's baby saying I'm late, and this was at 12:30 yesterday. And I might get a ride, and dad officially don't got time for me no more. He's making me learn to use my alarm and I'll be late because of it. I'm tired and exhausted, and Kenai won't wake up. And if I wake dad to wake up Kenai, he will yell at me. Like there's so much evidence, and that's why I'm asking for just to keep it the way it is until we can meet the guardian ad litem.
Do you have a guardian ad litem?
I was requesting one right now.
Okay.
I'm doing the best I can.
Yeah, here's what I'm going to do. I am going to find that there's adequate cause to move forward with discussing a revision of the parenting plan. I'm troubled that you're telling me that an adult male who you met recently is being put in charge of disciplining your joint child together. You can be surprised by that, but I don't find that acceptable at all.
I believe that you're misconstruing my words, but I am fully okay with moving forward.
Okay.
Hold
on, ma'am. It's my turn to talk. I also find that there's adequate cause based on the housing instability. And again, that is not a basis for finding you are an inadequate parent. It is a basis for finding that there's a substantial change in circumstances since you all entered the agreed resolution on September 6th. The court and you, ma'am, and Mr. Zimmerman all need to be sure that the children have a safe place to be when they are with both of you. Okay. I'm guessing that the agreed parenting plan probably well, I'll just say it sounds like it was presented to the court as an agreed parenting plan. You didn't have a guardian ad litem at that time. I agree with Ms. Zimmerman that you absolutely need one. I think the court needs one in order to determine what's in the best interest of the children. So I'm going to first sign the adequate cause motion. I am finding that there is adequate cause to hold a hearing on the petition. This does not mean I'm adopting the proposed parenting plan of Mr. Zimmerman. It means we are now going to move forward to start discussing what a new parenting plan should look like. I'm going to set a new hearing date in just a minute for that, but I am going to appoint a guardian ad litem. Let me ask you to just a little bit about your income so we can decide who's paying for this. Mr. Zimmerman, what's your monthly take-home income?
At the moment, my monthly take home is, I would say, $1,200 at the moment a month.
Okay. Are you working part-time, full-time?
I am in transition of starting a new job through Carl's Towing.
Okay.
So I'm not, at the moment, I am unemployed.
Okay. Do you receive any sort of state-based assistance?
No, ma'am, self-supported.
Okay. And then how many dependents do you take care of on that $1,200 a month?
Well, just the children that are here with me on my days. Other than that, it's just myself.
Okay. And then Ms. Zimmerman, what is your monthly income?
I am not sure because I was just getting ready. I started a new job just last week, and I was later today, I am finding that out for proof for HUD. And I start my second job, both part-time on Thursday, well, tomorrow.
Okay.
Yeah, I just now got daycare squared away to be able to be employed.
Okay, so here's what I'm gonna do. Right now, I'm gonna indicate this will be at county pay. 100% right now will be paid at county expense because you both meet the indigency guidelines. However, you're gonna see language in here where I state I'm reserving any reimbursement you may have to give for the GAL fee. The maximum total cost for a GAL is $1,485. The county is paying that right now. But we're going to reserve for a later hearing since both of you are starting new jobs. We'll reserve, I may inquire about your income at a later date to determine if there's any reimbursement that I would apportion you to pay towards that county cost, okay?
Once the case moves forward, the focus shifts to logistics, and money becomes the next pressure point. Both parents reveal unstable income situations, which changes how the court handles resources. Instead of delaying, the judge adapts by assigning the cost of the guardian ad litem to the county, at least temporarily.
Thank you, Your Honor.
Give me just a minute to fill out this paperwork and I'll come back to you with your new court date. Okay. So what we're gonna do, oh, thank you. Okay. So what we would normally do, and I don't expect any of you to have strong opinions, but I am required to read. Just a second, I'm getting another note. Okay. So Twyla, is it Corey?
Yes.
Twyla Corey is the name of the first GAL on our list. Heather Call is the second, and Amy Turnbull is the third. Do any of you know any of these individuals or want to strike them from consideration for your GAL?
No, ma'am.
No, Your Honor.
Okay, so then what we typically do is Twyla Corey, the first one on the list, will be who I appoint. Okay, so we'll get her appointed. Let me just set some future dates then. I'm gonna give you a few dates. So do you guys all have something to write with?
Yes.
Mhm.
Okay. So what I want to first do is I would like to set a review date on Wednesday, November 1st at 10:30 a.m. back on this docket. And that will be just a time because of the housing situation. I would like to be able to chat about whether we need to make any temporary changes to the parenting plan, depending on Ms. Zimmerman, your housing situation, if there's a place for the kids or not. But then we're going to set our next review 30 days out from now. That'll be the first time I expect to have some GAL input. So that'll be November 15, 2023 at 9 a.m.
And this one's to discuss what?
That will be so we usually give the GAL 30 days to meet with you all and issue some sort of kind of initial thought or, hey, court, here's where I think we need some follow-up, that sort of thing. So
Okay.
it's a GAL review. You both are present. And then we're going to go. That one is. I'm going to go 60 days out. Hopefully we don't need to go that far, but just to get them on the schedule, I think we'll do 60 days out for kind of our final GAL review. So that'll be December 20, 2023 at 9 a.m.
And what time was the November 1st? Is the same thing, 9 a.m.?
10:30.
I'm sorry. And Ms. Zimmerman's correct. I said 10:30 and I was wrong. It's 9 a.m. It'll always be 9 a.m. That was my misspoken time.
Thank you.
So all three of these review dates, November 1, November 15, and December 20 will all be at 9 a.m. Okay. And then can you give me the current ages of the children?
Yes, the Sarah is 13.
Okay.
And Kenai is 8.
Perfect. And then both of you, at least for now, are the addresses and phone numbers you have on file with the court your current addresses and phone numbers?
Yes, Your Honor.
Yes.
Okay. So then going back to the motion for adequate cause, what I'm going to mark on this is that we are going to set a hearing on the actual underlying parenting plan. Right now, we're going to set it for December 20, 2023. That's our review date that we think our GAL will have the report finalized. That's 60 days out.
Oh, yeah.
But if we have our early review dates and we think we can get it done quicker, I am open to changing that date sooner if that's what the parties want. But for the time being, the parenting plan in place is what you all will adhere to. We're just starting to move through this process of, hey, is this in the children's best interest? Okay.
Yes, Your Honor.
Okay, I think I've got everything filled out. Any questions for me?
I have one, Your Honor.
Go ahead.
With the drug allegations and the instability accusations, I already have an appointment set up for a mental health and drug treatment evaluation.
Great. Okay.
And willing to do a UA at any given time. I don't know if you are willing to make that a part of this for both parents.
So what I would typically do is wait on, because right now it's kind of just he said, she said, she said, he said. That's why I'm appointing the GAL. That's why I think it's a great idea. So the GAL would typically say, hey, I think court, this is something we want to do. So I'm going to wait at least for her first 30-day review. That said, taking proactive measures to show the court those things that you're doing, never a bad idea for either party. So, yep, kudos to you.
The final phase is all about structure. The judge lays out a timeline with multiple review points, creating a controlled progression instead of a single high-stakes decision. That's strategic. It allows ongoing monitoring, especially given the housing uncertainty. The guardian ad litem becomes the court's eyes and ears, shifting the case from accusation-driven to evidence-driven. The parenting plan stays in place for now, which stabilizes the situation while the investigation unfolds. The mother's proactive offer for evaluations is noted but deferred, reinforcing that decisions will be guided by independent input, not self-reported compliance. This ending isn't resolution, it's containment. The court builds a system that limits risk, gathers facts, and keeps both parties under continuous scrutiny until a clearer picture emerges.